Witness Mike, Judy. Witness Mike, Judy. Test 1, 2, 3, 4. Chair, Judy. 1, 2, 3, 4. Mic check. 1, 2, 3, 4.
Testing 1, 2, testing 1, 2. Testing 1, 2. Okay.
Good, we have someone. The committee will come to order. Today's hearing of the Subcommittee on Courts, Intellectual Property, and Internet will be dealing with issues of resolving issues with confiscated property in Cuba, which will include Havana Club rum and other property. The subcommittee ranking member may be able to join us, but has a conflict of interest, as will others. If they do attend, if they are able to be here, we will take their opening statements at that point. I would like to welcome everyone here today and ask unanimous consent the chair be authorized to declare recesses of subcommittee at any time. And today we have two distinguished panels, and I would ask, I guess we'll swear them in each panel. The witnesses have opening statements which will be entered in the record in their entirety. And I would ask, please, that during your 5-minute period that you summarize and stay within the 5-minute period. As you know, the red lights, green lights, and yellow lights will indicate go, hurry up, and stop. Before I introduce the witnesses, committee rules require that all witnesses be sworn, so what I'd ask that you please rise to take the oath. And raise your right hands. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Please be seated. Let the record reflect that all witnesses answered in the affirmative. Our first panel of witnesses will be the Honorable Kurt Tong, Principal Deputy Assistant Secretary of the Bureau of Economic and Business Affairs of the United States Department of State, and Ms. Mary Dennison, Commissioner of the Trademarks for the United States Patent and Trademark Offices. I'll now recognize myself for an opening statement. Today's hearing is on the integrity of the patent and trademark system. Over 50 years ago, the people of Cuba entered into an era of religious prosecution, property seizures, and political oppression. Families who had worked for years to build a future for they and their families lost everything and were forced to flee the country, or worse than that, be imprisoned in Cuban jails. In response to Cuba's alliance with the then Soviet Union, its totalitarian dictatorship under communism, America began a trade embargo to deny Castro and his allies the benefits of free trade. In 1999, American policy further prevented the recognition by the United States government of trademarks seized by Cuba. A drafting error in Section 211, or what has come to be known as a drafting error, made the legislation subject to a challenge by those who want to do nothing more than, in fact, trade with the dictator. To fix the drafting error, I have become an original co-sponsor of the No Stolen Trademark Honored in America Act of 2015. The law simply would the change in the law would simply take out references to a single country, but in fact still cover the category that would include the wrongful taking of these trademarks. In the case of the Havana Club example, a family business was seized at gunpoint with no compensation. Forced into exile, the family was unable to restart their business on their own and chose a partner with Bacardi, another company. The Ricard business of France chose to partner with the communist regime in Cuba and purchase and agree to distribute under the name Havana Club throughout the rest of the world. The United States, and I must say the United States alone, chose not to allow the sale and thus the profiteering by the Cuban government based on their theft. And let us understand clearly that we are still dealing with a Cuban-made product in which the people of Cuba work for maybe $20 a month to produce rum so the Cuban government can sell it at a price that benefits their regime. So the technicality that, in fact, we have a French government-owned, partially owned enterprise that will testify indirectly today that they bought it, and of course they're simply entering into business, is in fact inaccurate. In the case of the trademark in dispute, it was not a French company partially owned by the country of France, but in fact the Cuban government that applied for the trademark, the very Cuban government that had seized it illegally. With the passage of time, Cuban Americans also have sought to be repaid for stolen homes and businesses. On our second panel, we will have a former member of the Claims Board and a personal testimony of someone who is still trying to recoup that which was stolen from her family by this dictatorship. I'll now recognize the ranking member for her opening statement.
Why, thank you, Mr. Chair. I thank our witnesses for coming today, and I will say, excuse me, let me take a minute here to wrestle with the microphone. I was pleased when the President announced that he was working to normalize relations with Cuba. This shift in policy is really long overdue for a country that is 90 miles away, and we've denied American businesses. This is an issue that has been big in California, frankly, because there's a lot of Californian businesses across many different categories that are willing and ready to be involved in this important market. I want to take the opportunity here to say what I think is at stake here. There are hundreds of U.S. companies with thousands of trademarks that are registered in Cuba. So I'm worried that American businesses rely on the validity of the treaties that we sign to protect their interest abroad. The General Inter-American Convention for Trademark and Commercial Protection, the IAC, is such a treaty, and it's been signed by 10 countries, including the United States. And so I'm concerned that our actions will impact U.S. interests, not only in Cuba, but in 8 other countries who could subsequently choose not to honor the IAC. With regard to some of the issues that have come up, that I know will come up, like expanding Section 211, I agree that we risk doing more harm than good. I'm worried that when an entity as reputable as the National Foreign Trade Council tells me that we're about to violate a treaty that protects U.S. businesses, especially when considering that Cuba has consistently honored the IAC in favor of U.S. companies. So, for example, there's the Olin Corporation, who sought to protect its famous rifle trademark, Winchester. And based on the IAC convention, Cuba ruled in favor of Olin over a non-U.S. company. So I'm concerned that by looking at this issue, really when it's already in the judicial branch, that we run the risk of looking like we're trying to improperly influence an ongoing case. So those are my concerns, and I am hoping that through the testimony of the panelists that they can clarify this. Thank you, and I yield back.
Thank you. And we now go to our panel of witnesses. Mr. Tong, you have an opening statement. The gentleman is recognized.
Well, thank you, Chairman Issa, and thank you, members of the committee, and good evening. I appreciate the opportunity to testify today on topics related to confiscated property in Cuba, Havana Club rum, and other property. The protection of intellectual and real property rights is an important issue for American innovators, entrepreneurs, and businesses, and deserves the close attention and vigorous efforts of multiple branches of the U.S. government. In my testimony today, I will first describe briefly the role of the Department of State, and in particular my bureau, the Bureau of Economic and Business Affairs, with respect to intellectual property enforcement and protection and international claims and disputes. I'll also provide an overview of the recent claims discussions with the Cuban government. And then finally, I'll discuss the State Department's role in the Havana Club matter. The Department of State's Economic Bureau uses economic diplomacy to advance the prosperity and security of all Americans by working hand in hand with other U.S. government agencies and partners around the world to promote good economic policies, as well as to negotiate and implement agreements that shape the rules of global commerce. One of the department's foremost priorities is the promotion of innovation in the United States and around the world. We do this in part by advocating for effective protection and enforcement of intellectual property rights. Specifically, the department uses diplomatic outreach and programs and bilateral and multilateral negotiations to ensure the interests of American rights holders, as well as to highlight the critical role of intellectual property rights protections in supporting economic growth and stability. We also devote substantial resources to supporting the development of a satisfactory climate for U.S. investment overseas, which includes assisting U.S. investors involved in investment disputes with foreign governments. In this regard, we work closely with the Department's Office of the Legal Advisor, which represents the United States and coordinates activities with respect to claims and international disputes. In the case of Cuba, the Department is continuing to advocate for the resolution of all outstanding U.S. claims and disputes in our bilateral relations. We launched government-to-government claims talks in Havana on December 8th last year. And through these claims talks, we are seeking compensation or some other form of appropriate redress from the Cuban government for these long-standing U.S. claims. The U.S. delegation at the talks provided an overview of the U.S. claims against the government of Cuba. These include almost 6,000 claims of U.S. nationals related to confiscated property that were certified by the Foreign Claims Settlement Commission, as well as claims related to unsatisfied U.S. court judgments against Cuba, in addition to the claims of the U.S. government. The meeting in Havana was the first step in what is expected to be a complex process, but the United States views the resolution of outstanding claims as a top priority. With this in mind, I would like to finally address the specific case of Havana Club, which is a quite different sort of matter than the unresolved U.S. claims issues that I just mentioned. As you may know, this case concerns a dispute between foreign actors. On one side, a Cuban state-owned enterprise, Cuba Export, which is in a joint venture with a French company, Pernod Ricard, and on the other side, Bacardi and Company Limited, a company headquartered in Bermuda. These foreign companies are involved in pending federal court proceedings in the United States with regard to their dispute over ownership of the Havana Club trademark in the United States. The Department of State's role in the Havana Club matter was to respond to a request from Treasury's Office of Foreign Assets Control, or OFAC, for foreign policy guidance. To be clear, our role in the Havana Club matter was not to adjudicate the ownership of the disputed trademark rights, which is a matter still before our federal courts, and the Department took no position on that issue in its foreign policy guidance. To be a bit more specific, in November 2015, OFAC requested foreign policy guidance from the State Department with respect to an application from Cuba Export for a specific license authorizing all transactions with the U.S. Patent and Trademark Office related to Cuba Export's renewal and maintenance of the Havana Club trademark registration, including payment of necessary fees. The Department evaluated this referral in light of a number of factors, including the particular facts of the case, the recent shift in the United States policy toward Cuba, United States foreign policy with respect to key allies in Europe, and the U.S. approach with respect to trademark rights associated with confiscated property. After weighing these factors, the Department recommended issuance of the requested specific license. It is in the foreign policy interest of the United States that the relevant parties be able to reach a resolution in this long-standing dispute. As I mentioned, there are pending federal court proceedings, and the denial of a license and the resulting expiration of the trademark registration may have rendered those proceedings moot, whereas granting the license will allow the parties to proceed towards adjudication of their respective legal claims in the U.S. courts of law. In closing, I wish to reaffirm that the Department of State will continue to advocate for the effective protection and enforcement of intellectual property rights around the world, including and especially in Cuba. This effort is squarely in line with our enduring objective of the emergence of a peaceful, prosperous, and democratic Cuba. The administration's approach to Cuba allows us to effectively engage with Cuba on seeking redress for U.S. claims, for protection of intellectual property rights, and a number of other matters in the national interest. Thank you, Mr. Chairman, and I welcome your questions.
Thank you. Commissioner?
Chairman Issa and members of the committee.
If you could pull it slightly closer, your voice doesn't carry as well
How's
as the
this?
Secretary's.
Is that better?
Better.
Thank you so much. I appreciate the opportunity to describe the U.S. Patent and Trademark Office's role with respect to the renewal of the Havana Club trademark registration today. The USPTO is charged with carrying out the trademark registration process consistent with the law, so as to provide a stable marketplace for the sale of goods or services identified by the registered mark for the benefit of both consumers and owners. The USPTO receives more than 300,000 applications for trademark registration each year and administers a trademark register of more than 2 million active registrations. As a general matter, U.S. trademark law requires the submission of certain documents and the payment of appropriate fees to maintain and renew a trademark registration. The actions we took at the USPTO in this case were straightforward and consistent with the law. In 1974, Cuba Export applied for registration of the Havana Club trademark at the USPTO. The USPTO approved the registration in 1976 and renewed it in 1996. The transactions were authorized under an existing general license pursuant to the Cuban Assets Control Regulations. In October of 1998, however, Congress included Section 211 as part of the Omnibus Appropriations Act, which rendered that general license unavailable for transactions or payments for certain trademarks. As a result, when Cuba Export attempted to renew the Havana Club trademark registration in 2005, the Treasury Department's Office of Foreign Assets Control, known as OFAC, advised the USPTO and Cuba Export that a specific license would be required to authorize the payment of renewal fees. Cuba Export could not legally pay the required fees without an OFAC-specific license authorizing the transaction. Cuba Export applied for a specific license from OFAC, and OFAC denied the application. Because the requirements of trademark law could not be met without an OFAC specific license authorizing the fee payment, the USPTO was unable to renew the registration. Cuba Export then sought review of the USPTO's refusal by filing a petition with the USPTO, the same petition that we acted on in January. Because Cuba Export also sued OFAC over its decision not to issue Cuba Export a specific license authorizing the fee payment, the USPTO suspended action on the petition until that litigation was over. Cuba Export's challenges in federal court were ultimately unsuccessful. In November of 2015, Cuba Export submitted a new specific license application to OFAC, and OFAC issued the requested license on January 11, 2016. On January 12, 2016, Cuba Export supplemented its USPTO petition to include an OFAC-specific license authorizing the 2005 payment of fees and all other transactions necessary to renew and maintain the Havana Club registration. Because Cuba Export had satisfied the requirements of the Trademark Act, the USPTO took action to accept the now authorized fee, to grant the petition, and to update the USPTO's records to to reflect the renewed status of the Havana Club registration. This action does not, however, decide the Havana Club trademark dispute. The rights of all interested parties remain the same as they were before the action was taken. That concludes my statement, Mr. Chairman, and I would be happy to answer any questions. Thank you very much.
Excellent. I now ask unanimous consent that the entire list of the 6,000 certified recipients under the Foreign Claims Settlement Act be placed in the record. Without objection, so ordered. Additionally, I ask unanimous consent that the June 11, 1974 attached a complete set of documents applying for the trademark by the country of Cuba, entered by the law firm of Hassline, Lake, and Walters, be placed in the record. Without objection, so ordered. Additionally, the testimony of Ramon, and I apologize in advance for how I'm going to get this, Aracabala, Ramon's testimony of 2004 be placed in the record. Without objection, so ordered. Additionally, the Washington Post article of February 1st, 2016, Failure in Cuba, be placed in the record. It is an editorial. Without objection, so ordered. Lastly, an exchange of documents. My letter yesterday to the Secretary Kerry and Liu, along with attached signatures of a number of other congressmen, be placed in the record. Without objection, so ordered. And then the exchange of documents. Yeah. And I'd like to make sure the record indicates that the ranking member is not here as a result of a conflict of schedule, the interest being the schedule, not a conflict of interest. I know I did, and it absolutely, he simply has another scheduled event, so that is the conflict. And with that, I'd ask unanimous consent all members' opening statements be placed in the record. But, Mr. Chairman, would you like to ask a round of questions? Okay. In that case, I will go first and ask my list of questions. And, Commissioner, I probably only have one question, a couple of questions for you fairly briefly, but one of them is you didn't mention 2012. That was when all the cases were resolved, and the Commission could have vacated all the documents, correct? In other words, 2012, when the cases were decided, in the ordinary course, this application would have been gone. The trademark would have been available under common law and registration law. Isn't that true? You said you had held up and suspended this case while other cases were pending, but those cases were resolved, what, 2 years ago?
There was litigation that was pending.
Just when did the last piece of litigation end, to your knowledge?
In 2012.
Thank you. So litigation ended in 2012. Your excuse for holding up and keeping this in limbo so that the administration could act ended in 2012. Isn't that true? You had no valid reason to leave this file open as it was, did you?
Mr. Chairman, let me explain a little bit about the petition process.
No, ma'am. I appreciate the petition process, but I only have 5 minutes. On what basis? There was a conflict known. There was a competing company that had purchased the rights from the family, was sharing the profits in those sales with the family, and they, in fact, also had valid applications, and they had been selling the product in common law since 1994. So in 2012, on what basis did you keep this open so that you could retroactively go back to 2005?
Well, first of all, there is no set time frame for us to issue a decision on a petition.
Okay.
We receive thousands of petitions every year, and some of them are acted on very...
Well, I know you acted on this one in 3 days.
And some of them are acted on in a matter of years.
Okay. So let me just make one thing clear for the record. From 2012, any statement that you were waiting on a court case to end, ended. And from 2012 until 2015, the case simply sat open waiting for OFAC or somebody else to do something because there was no, your basis for suspending had ended. Isn't that true?
Actually, after the litigation ended, there was an extended period where there was back and forth between our office and OFAC before we could have acted.
Yeah, but that wasn't the question, Commissioner. The question was, you said in your testimony that you held this in suspense because of a case. Now, that case went to the U.S. Supreme Court. Ultimately, they, by not granting cert, affirmed the lower court case, and it was over. The Supreme Court had spoken and essentially allowed the lower court. So there were no court issues left. So the fact that you were going back, in fact, with OFAC, all of that is a political question and answer, so to speak, to do with the current administration. And, Mr. Secretary, I think you said it very well. You were trying to reach out to deal with Cuba relationships. So this became a tool, I would gather, in that negotiation. Isn't that correct, Mr. Secretary? That this was on the table as part of negotiations?
The issue of Havana Club, to my knowledge, was not discussed in our conversations with Cuba regarding the normalization of diplomatic relations.
Okay, so it was never on the table, you're saying, as far as you know.
As far as I know.
Okay, Commissioner, would you provide us with written communications and memos related to correspondence with other agencies outside the Patent and Trademark Office for purposes of the decision process related to the delay until 2015?
Yes, I can. I'm not sure there is any.
So it's just oral conversations, just chatter?
To my knowledge, there is no written communication.
Okay, well, if you would check, I would appreciate it. Mr. Secretary, I've got a question for you. You said in your statement that your goal, the administration's goal, of course, is to restore people, to strengthen personal property and the like. I'm going to use a little bit of demonstration. Here's two tangible bottles. This one is Cuban-made. It's empty. This one is American-made. It's full, or half full. No, not by my consumption. These are tangible products. This one is made in Puerto Rico, where there are about 1,400 workers, American workers, earning $40,000 or so a year. This is made in Cuba by people making about $20 a month. Now, under your decision, people making $20 a month are going to be shipping this to the U.S., and people in Puerto Rico making $40,000 a year are going to be laid off. If I take it to its logical conclusion, I could hold up bottles of Bacardi, which the Cubans have the exact same claim on, that they seized it, it was theirs, and they asserted around the world that it was there. Would you have the $100 million that the Puerto Rican government gets from Bacardi tax revenues every year and the 1,000-plus jobs eliminated by giving Bacardi back to Cuba as a question of renewing our policies? Is that on the table? And is there any real difference from a foreign policy of whether or not you give away one family's rights or another's?
Thank you, Mr. Chairman. In my understanding is that the economic impact of the patent or the trademark registration has not yet played out. That the ownership of the Havana Club trademark continues to be a matter before U.S. federal courts, and that matter will be settled in U.S. federal courts.
Well, you know, the man who was taken from has died, so I'm not sure that there'll ever be justice in that economic impact. And the son is working for a company and not able to produce the product his family had produced since the 30s. But my time has expired. I have to be sensitive to all here. The gentlelady from California, Ms. Bass.
Thank you, Mr. Chair. I wanted to know if either witness could talk a little bit more about Section 211 and the impact of that. You know, as I'm reading some of the material here, the Cuban government has threatened to violate the trademark rights of U.S. companies because we haven't repealed Section 211, and I guess there's some consideration about expanding it. So I'm wondering if you can talk a little bit more about that. And also, within the context of that, discussing the possible implications for U.S. business interests in the 8 other countries who are part of the IAC. So I know in some instances it's viewed that we might be violating the international treaty, or it'll weaken our ability to protect U.S. intellectual property interests in the 8 other countries. So perhaps you could comment about 211 and explain. Either one. whichever.
I guess I can start, and my colleague may want to amplify. The Section 211 is a statute which is under the interpretation of which comes to OFAC. So I can't speak to on their behalf with regard to that interpretation. But my understanding is that a specific license can be granted just regardless of the existence of Section 211. With regard to the broader diplomatic elements of intellectual property rights protection, this is something that we obviously work on very, very hard with a lot of countries, and we're looking forward to the opportunity, as I said earlier, to pursuing the protection of intellectual property rights in a vigorous fashion in Cuba, now that we have a better opportunity to pursue those protections. The question of Section 211 has come up in the World Trade Organization, and the United States was if you will, taken to dispute by a dispute settlement by the European Union some years ago with respect to Section 211, and that was a long-standing point of disagreement between the United States and the European Union. Since the granting of the specific license and then the trademark to Havana Club, there has been a noticeable lessening of the European Union's level of interest in that issue. So in a sense, we have made some progress in the overall strategy of intellectual property rights protection and cooperation with Europe as a result of this one specific case.
Should it be repealed, that section?
I don't have an administration position to convey to you on that matter.
Do you know of any instances in which Cuba has failed to honor its obligations under the IAC in relation to U.S. companies?
I'm going to have to get back to you on that because that's a rather specific question and I'm not researched on it.
Do you have any concern over the thousands of trademarks that are registered in Cuba from U.S. companies?
Absolutely. My understanding is that there's somewhere in the range of 5,000 U.S. trademarks that are active in Cuba, and the protection of those trademarks is of great interest to the United States, and we need to pursue it vigorously.
So one of the questions is, if we move toward closer and better relations with Cuba, are we in a better position to protect those trademarks than if we were to roll back the direction that the administration is pursuing now?
In the administration's estimation, yes, we are in a better position to pursue this entire topic of intellectual property rights protection with Cuba based upon our recent approach. In fact, we've gotten some positive feedback from the Cuban government with regard to their openness toward having detailed and specific conversations about intellectual property rights protection.
Thank you. Would you like to add anything, Ms. Stinson?
I think he did a great job.
Okay, I yield back my time.
Gentlelady yields back. The chairman of the full committee, Mr. Goodlatte.
Thank you, Mr. Chairman. I appreciate your holding this hearing. I submit my opening statement for the record, and I'm happy to yield to you so you can continue your excellent line of questioning.
Well, I'm going to continue somewhat, but I'm going to change a little bit. Commissioner, H.R. 1627, you've seen the legislation that proposes changes to 211, correct? And it does eliminate any specific reference to Cuba, and it makes 211 essentially an impediment to those who would steal somebody's property and then try to gain in another country and then gain use of it here. Do you have any questions or doubts about its validity under WTO?
I'm sorry, could you repeat the last part of the
H.R.
question?
1627,
Yes.
you could implement it if it's passed by the Congress, right? The Trademark Office hasn't issued any objections or anything that would cause us to think you have a problem.
I understand there are a number of proposals pending, and there is no administration position on any of them, to my knowledge.
Well, that's why you're a commissioner. Have you read it, and do you have any problem with it?
I'm not authorized to state a position without the administration position being
I'll remember that when we talk about the independence of commissions. Mr. Secretary, since they've sent you here, you mentioned that you were concerned about 211. You mentioned that essentially giving this trademark back to Cuba ameliorated friction between us, our French partners, and so on. Where does the family get compensation for your benefit? You got the benefit. You've improved relationships. The original owners got screwed, right? Are you planning to make them whole in return for the benefit you got?
Well, my understanding is that the trademark...
You traded real property that belonged to somebody.
Thank you, Mr. Chairman. The trademark in question is being litigated in U.S. courts as of this date.
74. Okay, well, let me go through a question. Commissioner, I hope you could answer this without going back. And I'm not sure you can, but in 1974, the Cuban government applied for a trademark, and it was granted. There was an embargo at that time. They could not legally give you $35. Where did they get permission to give you the $35? And I understand that some law firm submitted it and somebody in Luxembourg did it, but the mark went to Cuba, therefore it was clearly Cuban money. On what basis did you grant them the trademark, to your knowledge? What was your legal authority to take that $35 then?
Thank you for the question. When Cuba Export applied for the trademark application in 1974, they were allowed to proceed under the general license provision of the Cuban asset control regulations. So there was no problem accepting money.
You had no problem accepting their $35?
That is correct.
Okay, well, we'll check into that. That's not what we're told. Additionally, they, instead of an intent to use, they filed based on having a trademark in Cuba. They simply submitted an attached trademark from Cuba and said, this is our application for the same, correct?
Yes.
Okay. Now, interesting thing about trademarks, if anybody other than Cuba applied for a trademark, let's say Darrell Issa, and then went more than a decade of not selling one single drop, one single bottle, would their trademark still be valid and enforceable?
It might be if they could show, there's a section of the statute that is called excusable non-use, and in certain certain situations, use is not required. So, for example, if there's an embargo.
Well, let me go through that, because the embargo is
excusable.
exactly what was in place. At the time of the application, there was an embargo. So they filed saying they were going to do something that they couldn't do legally and can't do today. Isn't that true?
No, that's not correct.
Can they ship to the United States today, madam?
No, they cannot.
Could
but
they ship to the United States in 1974?
No.
Has there been any period of time between 1974 and today in which they could ship to the United States?
No.
Do you ordinarily accept and provide trademarks excluding others when in fact they're not entering commerce?
We have to honor our treaty obligations, and this was filed under that treaty obligation.
Okay. Now the
That is-
family,
No,
through-
Section 44. yeah.
right, the family through Bacardi has tried to renew their activity and in fact has an application pending. And the only thing working against them is that when they had no money, extenuating circumstances, they were unable to file their renewal. And they were poor and destitute because all of their assets had been seized. Isn't there a provision in the law that would have allowed the family to be able to renew their trademark in 1974, 5, 6, and in fact say that these circumstances prevented it, and that circumstance was in fact the confiscation of our assets, and so on? Isn't it within the power of the trademark office? You could have made a decision to renew their trademark too, couldn't you?
Are you referring to the trademarks previously owned by the Archibald family?
Yes.
They could have claimed excusable non-use.
So, last quick point. In 1974, the trademark was not codified, right?
In 1974, the Archibald family did not have any registrations on the U.S. Register. Is that your question?
No, in 1974, they entered into what had been a latent, never mind, you know what, I'll wait for additional time. I don't want to take from other members. The gentlelady from Washington's been patiently waiting.
Thank you, Mr. Chair, and thanks to both of you for being with us today. Commissioner Dennison, in your testimony, you note that the PTO's decision to accept the authorized fee payment and the most recent Havana Club petition in no way decides the Havana Club trademark dispute. So I wondered if you could elaborate on why this is and comment on the distinct roles that the PTO and the courts have in resolving such a dispute.
Thank you very much. And by the way, we appreciate your participation in the Trademark Caucus.
Thank you.
So when the Trademark Office is presented with documents for renewal, we look at the documents. We do not examine ownership at that point in time because of treaty obligations that we have, which restrict our ability to examine ownership in the post-registration renewal period. And we only look at the ownership if, in fact, there is someone who sends the documents in does not match the name in our records. So we don't have the resources to investigate the ownership, and people are required to declare under penalty of perjury that they own it. So what happens is if there is a dispute, people file cancellations. And so, in fact, that is what has happened here. Bacardi has filed a cancellation proceeding, and that is now in federal court. So we are not the ultimate arbiter of ownership. That is where we hope the ownership dispute will be resolved in the federal court case that is now pending between Bacardi and Cuba Export. When you get a registration, you just get a presumption of ownership. And then when it's challenged in court, that can be rebutted.
Thank you. Secretary Tong, in your view, has the administration's decision in any way dictated an outcome in the trademark dispute?
Thank you for your question. No, in our view, this trademark dispute will be settled in federal court.
And in terms of any intervention that Congress might do, what are your concerns about that at this point in time? Or if either of you have concerns?
Well, I'm not sure I have any particular concerns to express beyond the fact that to once again express the really strong determination of the administration to make the protection of intellectual property rights and the pursuit of the legitimate claims of U.S. nationals who have had their property confiscated by Cuba are very vigorous pursuit of both of those initiatives going forward, and we believe that recent circumstances and events have strengthened our capability to do so.
Commissioner, do you have any additional comments on that either? Okay. Thank you both for your time, and I yield back, Mr. Chair.
Would the gentlelady yield just a clarifying question you had?
Yes, I yield.
Thank you. When you said U.S. nationals, would those include people only at the time of the seizure in 1960, or would it include all of the Americans who exist today who fled afterwards and whose assets were seized while they were still Cuban nationals?
Yeah, thank you for that question. I think it's an important point of clarification. Our claims talks that began last December are pursuing three areas. The first and most important is the claims of some 6,000 U.S. nationals of a total value of approaching $2 billion, a very significant amount. The second is claims of the U.S. government. And the third, I'm afraid I've forgotten right now, but I'm sure it's also very important. But it
could be Cuban nationals who are now Americans.
But the Foreign Claims Settlement Commission Mr. Chairman, I think this is an important point, has under statute only been able to accept the petitions of people who were U.S. nationals at the time of the property being taken.
So the Bacardi family and all the other families involved who fled Cuba after a dictatorship seized their assets are not covered by anything you're doing today, is what you're saying?
Under the current laws and statutes that we have to work with, that Foreign Claims Settlement Commission is...
No, I apologize.
required.
I'm on the gentlelady's time, but the question was, are you pursuing on their behalf not something about the claims? You certainly have the right to bring up a whole host of families, including, to be honest, the Bacardi family who can't sell Bacardi rum in Cuba, not just Havana Club and their family. So the question, I just want to make sure the gentlelady's question, which you answered, was answered that, if I understand correctly, no, you are not dealing with those who came to America escaping persecution. We have, you know, people a person on the next panel that fits that description. That's why I asked.
So I will take your question and concern back to the State Department. I think it's my understanding is that, again, that we are pursuing first and foremost, and at this point exclusively, the property of people who were U.S. nationals at the time of confiscation.
Thank you. Mr. Marino.
Thank you, Chairman. The question I'm going to ask, I would like each of you to respond to, if you would please. Has anyone from the administration, the Obama administration, whether it's the White House, whether it's state, anyone that you work for, anyone you work with, has anyone said to you that this issue cannot be part of or get in the way of the reinstating of diplomatic ties between the U.S. and Cuba? Secretary. No, Commissioner, go ahead.
Sorry, I answered first.
That's all right.
The answer is no.
No, Mr. Secretary.
Again, to my knowledge, in the course of the conversations that the U.S. government had with the Cuban government about the resumption of diplomatic relations, as far as I'm aware, the matter of Havana Club did not come up.
Do you know if there were any communications with anyone else in the White House pursuing this matter within any other department or agency in the U.S. government?
Again, to my knowledge, there was no quid pro quo, and this was not a question of negotiation. The Havana Club matter is a matter of U.S. regulatory action, and then now, after that regulatory action, now it's a matter before the U.S. courts.
Commissioner?
I'm sorry.
Do you know of any communication, if there exists, between the White House and any other department or agency concerning the issue with this patent?
Yes, there were communications from the White House to the USPTO staff at some point regarding what the procedure was for the petition.
And do you know where that communication went and what was the intent behind it?
I don't know what you mean by where it went, or...
Well, the White House communicates to staff at USPTO, right? What was
Yes.
their request, or what were their instructions?
To the best of my knowledge, there were no instructions. It was an inquiry, and we provided information.
Marino, can I provide a clarification?
Please.
I don't want to leave you with the impression that the Cuban government has never raised the Havana Club issue with us, because they have raised it with us.
I'm sure.
But it was, that won't surprise any of us, but it was not, to my knowledge, a matter of negotiation or of any quid pro quo in the discussions with Cuba.
Now, you said that, Mr. Secretary, you said that state is seeking claims. For whom are they seeking, is state seeking claims specifically?
We're seeking compensation from the Cuban government.
For whom?
On behalf of 6,000 odd U.S. nationals who were U.S. nationals at the time that their property was confiscated.
And how's that going?
Well, it just got got started, and obviously it's going to be a complex process. We were, at the initial meeting, able to lay out the full scope of our claims and the rationale behind them, and had that initial discussion. But we're asking for compensation, so it will be I don't want to handicap the process for you, sir.
When you say you're asking for it, is there going to be some restrictions concerning Cuba if they do not agree to compensate these people? Is there going to be any retaliation from the U.S. government that you know of?
I don't want to comment on the negotiations per se, and perhaps we can follow up and have the people that are directly involved in those negotiations have a conversation with your staff to explain more about the course and the strategy of those negotiations.
Now, a question for the two of you I have in 34 seconds. Do you think either state or USPTO, or you personally, had the responsibility of raising the issue with the administration pursuant to the administration's move to begin diplomatic ties again with Cuba and raise the issue with the White House over this issue concerning the patent?
I did not think I had any obligation to raise it with the White House, no.
You knew of the existing complications in this case? People claiming to have ownership and then...
I'm aware that there are a number of people claiming ownership in the Havana Club mark. We have pending applications, not just from Bacardi. There is also, and I apologize if I mispronounce it, the Archibala family. There is a pending application from them. There was a pending application filed last year by somebody named Mr. Solar. I think he abandoned recently. But anyway, there are multiple parties claiming ownership.
All right, my time has expired. Thank you.
Just to follow up, just one thing. You did mention to the gentleman from Pennsylvania, communications with the White House. But then earlier you said there was no document. Is this all oral communication?
Yes.
Okay.
To the best of my knowledge.
Okay. Can you provide us memos and any other information that may exist related to the, in your business, everyone does a memo for the record. Could we have any of that exists that we could understand the context?
Yes, Mr. Chairman, if it exists.
Thank you. We now go to the gentleman from New York, Mr. Jeffries.
Thank you, and I thank the witnesses for their presence here today. Commissioner Dennison, I want to go over some issues related to the excusable non-use doctrine, some of which you may have already covered, and then build upon that to the extent time permits. Just so that I'm clear, to obtain and maintain a trademark registration, the mark owner has to show use. Is that correct?
In order to get a registration to begin with, most people have to show use in commerce. There are certain exceptions, though, to honor our treaty obligations. And so in those cases, those people would not have to show use in commerce to obtain a registration. However, everyone has to show use in commerce as a general rule between the 5th and 6th year of the registration date. The exception is if you can prove excusable non-use, which is provided for in the statute. And we did talk about it a bit earlier.
Now, let me ask about that. In the case of excusable non-use, am I correct that it's a temporary doctrine in its application?
There's no restriction on it in the statute.
Okay. Now, under U.S. trademark law, non-use of a trademark from 3 consecutive years, as I understand it, creates a rebuttable presumption of non-use. Is that right?
That's a different concept. That is a rebuttable presumption of abandonment.
Right. But that relates to non-use, correct?
It does. It's sort of a complicated legal interpretation, though.
Okay. And it's 3 years, which is what creates the rebuttable presumption, true?
Yes.
Okay. Now, how does that legal concept work in the context of a trademark that's been registered since 1976, but has never actually been used in the context of U.S. commerce?
Well, the excusable non-use part of the statute, I'm going to have to ask my legal team for an opinion on this, but I think that the excusable non-use can trump any claim of abandonment.
Okay. I'd be interested.
Get back to you on that, though. I'd like to
in
consult.
some clarification.
That's a complicated legal question you asked me.
Okay, no, thank you. Well, I should thank my staff for that complicated legal question, actually. Let me ask.
It was a good one.
Let me explore a different concept. Now, it's my understanding that there's a principle under law, which I guess technically is referred to as geographically deceptively misdescriptive goods. Is that correct? It's kind of an awkward phrase, but that's the concept, correct?
Yes, there is such a concept.
Now, in terms of that concept, could you just elaborate on, I believe there are 4 factors connected to that principle in the statute, one of which, I think the one that grabs my attention or the 2 that grab my attention are, 1, the primary significance of the mark is geographic, and 2, purchasers would likely believe that the goods or services originated in the place named in the mark. Is that correct, in terms of 2 of the factors, 2 of the 4 factors connected to this principle?
That sounds right. I don't have the statute in front of me, but, that sounds generally correct.
I'd be interested, sort of in your opinion as it relates to the Havana Club mark. And this was an issue that some of us explored when we were in Europe as a judiciary committee related to the concept of champagne in France and understanding what's the difference between champagne and sparkling wine. In the context of the Havana Club mark, is it your understanding, I believe, it's correct that the Havana Club rum was actually made in either Puerto Rico or the Bahamas, is that right?
Excuse me, are you whose Havana Club are you talking
The
about?
Bacardi rum.
My understanding is it is not made in Cuba.
Correct, that it was made in Puerto Rico or the Bahamas. And
I honestly don't know where it's made. I think it may have been made in Puerto Rico, but I did not know it was made in the Bahamas.
Right, we might be able to clarify that if time permits with the second panel, but what I'd be interested in...
The gentleman, for the record, it says San Juan, Puerto Rico on the bottle.
Okay.
The bottle's open if you want to inspect.
It's tempting. And so my time has expired, but if the chair would permit, I'd be interested in your thoughts on your views as it relates to this particular concept of geographic deception as it relates to a Havana-related mark put on to the market by Bacardi with the rum actually being made in San Juan, Puerto Rico.
I believe, thank you for your question. I believe that when we were examining the Bacardi application many years ago, that was raised as an issue in the Bacardi application, the fact that it could possibly be geographically misdescriptive, deceptively misdescriptive, if the rum was not in fact being made in Havana.
And as far as you know, that's an open legal question?
Well, the application is still pending.
Okay, thank you. Thank you, Mr. Chair.
Thank you. We now go to the gentleman from Texas, Mr. Poe, for his round of questioning. And well, mine's working, but I really didn't touch yours. Try see if maybe we haven't done anything. Mr. Ron, does yours work?
Yep.
It's just you, Ted.
Sure it is. It always is. This issue, as maybe some of you know, I used to be a judge, and the more I hear about this specific case, the more I'm glad that I tried criminal cases, bank robberies, kidnappings, murder cases. Be that as it may, let me see if I can let's look at this from a big picture situation. Cuba export is the Cuban government. Is that correct?
Yes.
And it's really the military portion of the Cuban government that runs a company. And if you want to export something out of Cuba, you work through Cuba Export, which is a government, military-run corporation that sometimes partners with other people throughout the world, like the French in this particular case, to sell a product abroad. Is that a fair statement?
I'm not prepared to opine on Cuba export.
Well, this whole thing's about Cuba Export. You don't know anything about Cuba Export? Neither one of you know anything about Cuba Export? This isn't a gotcha question. I'm just trying to lay the foundation of who the people are we're talking about in this case.
Yeah, thank you, sir. Cuba Export is a state-owned corporation, so it is owned and managed by the Cuban government.
Cuban government, primarily the military. So what happened when the revolution happened? The Cuban government swoops in and steals property from Cuban nationals and from foreign nationals, foreign corporations, and nationalizes the property, makes it theirs. Then they set up another corporation called Cuba Export to run these companies like Bacardi and sell stuff abroad. They partnered with the French in this particular case, and this dispute is whether or not the United States, the trademark, and they should still be allowed to sell or not sell, and whether Bacardi in Puerto Rico can sell or not sell. I mean, is that a generally rough statement of what's going on in this particular case? Or not?
The case is certainly a matter. The trademark dispute is definitely one between, and you'll be hearing from them in your next panel, I believe, Cuba Export, which is a state-owned Cuban corporation, and Bacardi, which is not.
Okay. And so we're in a position where Congress is considering, under legislation, to weigh in on this particular case, and we make a verdict. We'll make a verdict based upon the legislation filed by the chairman, or we let it play out in the judicial system, in the courts, the federal courts, where this particular case is now. Is that right? The case is in federal court.
The case certainly is in federal court, and sir, if I could make one observation on that, as someone who is charged with the promotion of intellectual property rights overseas, it's a matter of pride in explaining the strength of the United States intellectual property rights system, that we do have a court system that operates well and considers the merits of each case in a proper fashion.
Right.
And I must say that I'm confident that our court system will provide the most high-quality judgment in this case compared to those of any other country.
And I generally have the belief and ruling that, or feeling that if something's in the court system ought to settle the issue, and Congress should really stay out of it, as a general rule. I'm not talking about this particular case. But when we are dealing with the Cuban government now and trying to open it up and be more, have a better relationship with Cuba nationally. And my concern is similar to one that Mr. Marino, who used to be a federal prosecutor, said. We're dealing with Cuba, and my belief is we do a lousy job when it comes to dealing with someone that's an adversary. The Iranian deal is a perfect example, in my opinion. I think that was a bad deal for the United States. Now we're dealing with Cuba. Are we dealing with them through strength or through weakness in our political dealings with Cuba? Of the 6,000 claims, the Cubans, they don't take back convicted criminals that are ordered deported back to their country. They don't take them back. China doesn't take them back either. And it's very difficult to deal with the Cuban government on a level playing field. So are we giving up our strength in dealing with Cuba diplomatically over these claims, over this case, over the other cases that include Americans, that don't include Americans, that include Cubans, in your opinion? Or are we fighting for, what we want to be fair in the outcome of our relationship with Cuba and what they have done in the past to steal everybody's property?
I think you've raised an important matter here, sir. And yes, the U.S. government is pursuing the claims of U.S. nationals against the Cuban government with great vigor and we believe in a intelligent fashion, which is by creating an environment where we can actually engage with the Cuban government and seek resolution of those claims across the table, presenting our case clearly and scientifically to the Cuban side. And I must say that in the estimation of the administration, the fact that we have faith in the fairness of our own court system to adjudicate this trademark dispute actually adds to our legitimacy and strength in pursuing that conversation with Cuba. We don't agree with Cuba on everything by any means, but our demonstration of confidence in our democratic system adds to our strength in pursuing these claims.
Well, I would agree with you on the comment about our judicial system. It is the absolute best in the world. But I'll yield back to the chairman.
Mr. Poe, where would you put the Cuban judicial system in that hierarchy of best to worst?
Well, first of all, it's a misnomer. It's not a Cuban judicial system. It's just a system. So it's not much of a justice system, but it's just a system.
Thank you. And with that, we go to the gentleman from Florida, Mr. DeSantis.
Thank you, Mr. Chairman. Mr. Tong, you were talking about trying to create conditions to get results here, but the President's policy change was announced, I believe, in December of 2014. So since that point, how many certified claims have been paid by the Cuban government to U.S. citizens?
None yet, sir.
That's what I thought. And when you have discussed the issue, I think in their testimony you said that they have been provided an overview of nearly 6,000 certified claims. How did the Cuban government officials respond to that?
I was not a participant to those negotiations, so
Do you know if
I don't
any
think
commitments were made?
they listened to the presentation of the U.S. claims and were beginning a complex process of pursuing them with great vigor.
So that's a way to say no, I think. There was no commitments made, correct?
We're still just getting started in this conversation.
Well, I get that. I just think that when you're dealing with a regime of this nature, from their perspective, they've received all these concessions. I mean, a lot of cash they're going to end up getting, and they really haven't done anything for us. And I think that they're just going to keep doing this and try to pocket concessions. So I think that this has been a mistaken approach. Now, let me ask you this, Commissioner. As a general matter, seized trademarks, should those be registered to those who seize them or to the rightful owners?
The situation with Havana Club is that we registered it because they were permitted to pay under the general license.
I understand, but I'm just saying as a general matter, when you have trademark that's seized, is it better that the person who seized it is recognized, or is it better that the person who originated it is recognized? Will it be better policy?
It's not my job to opine on the law that you have put into place. Congress has put into place Section 211. So if there were another situation and another special license were issued, I would be in a situation where I had to take the money.
Well, I'm glad you mentioned 211. What type of legal analysis, if any, did the Patent and Trademark Office undertake before departing from the precedent, the longstanding precedent following the language of 211 with respect to this issue?
I think it's important for you to understand that Section 211 is administered by OFAC, and so once we received the specific license, we were not involved with the OFAC decision to issue a specific license, but once we received the specific license, the law had been complied with, and we didn't have an option. We had to issue the renewal.
So you did not do any separate legal analysis for that reason. Is that what you're saying?
Correct.
Okay. Well, Mr. Chairman, I appreciate you calling this hearing. I think it's something that's very frustrating to see, the Cuban government seizing all this property. This has been going on for decades. And it seems like they're going to get away with a lot of this stuff. And, you know, I think that's a real tragedy. But I know we have the next panel coming up, and so I will yield
Would the gentleman yield for just 1 second?
for 1 second.
Mr. Secretary, did you do a legal analysis? They asked the commissioner, but since you folks, you and OFAC, was there a legal analysis done by state who effectively made this happen while tying the hands of the PTO? Ms. Dennison has made it clear she had no choice. You had a choice. What was your legal analysis for it?
We also followed the guidance of OFAC and the interpretation of.
So I need to get OFAC here to find out if they did a legal analysis.
Yes, sir.
Okay, well, I guess that's what the empty chair is for. Thank you, Mr. DeSantis. We now go to Mr. Deutsch, another gentleman from Florida.
Thank you, Mr. Chairman. I just, and I apologize, I had another meeting, but I just like to walk through a couple of points. Secretary Tong, as the administration moves towards normalization, there's been broad recognition, widely discussed, that confiscated and disputed property claims have to be resolved, and I absolutely agree with that. What I'm confused about is how it was that we decided before any of the many claims that are out there that have been the focus of much discussion, before any of those claims are resolved, that we would toss aside this heavily disputed trademark. Why was Havana Club marked first on the list?
Our handling of the Havana Club registration, the State Department's role, to be very specific, was to provide foreign policy guidance to OFAC in its decision about whether to grant a specific license that provided Cuba Export the ability to pay a fee, which would allow them to register a trademark.
Right, and you had said, I'm sorry, but you had said earlier, or you'd said in your testimony that specifically you'd said that that the state's role was not to adjudicate the ownership of the disputed trademark rights, and the department took no position on that issue.
Correct.
But how is it that granting of an OFAC license is not taking a position on the issue? And here's the question, here's why I rushed back here as quickly as I could. Shouldn't we clearly bar the recognition of any sort if the mark was used, if the mark that's used was used in connection with a confiscated business and the original owner hasn't consented? And aren't we just legitimizing the confiscation and then telling the original owners to take their objections to court? And I hope that it's not going to be a broader reversal of what has been U.S. policy to not recognize any interest in confiscated property. And I also hope that it's not a foreshadowing of the process that might be used in future Cuban confiscated property claims resolution.
So there was a lot in what you said. Our action, the State Department action again, was to issue foreign policy guidance that then informed a decision to allow a trademark registration. That trademark registration is now a matter of dispute in U.S. federal court. So the U.S. administration action, in particular State Department action in this regard, as I said, was not to adjudicate this claim, but rather it creates a situation where it will be adjudicated in court. But
to go to
if
court.
I could,
No, but I just want to follow up on that point. So, but that gets to the question I asked. Isn't that just essentially legitimizing the confiscation and then telling the original owners just simply take your case to court?
well, in the question of broader claims of U.S. nationals against the Cuban government, I've stated several times this evening that we are pursuing those with great vigor and we believe with an astute strategy, sitting down directly with the Cuban government to address these claims of 6,000 people worth close to $2 billion. And we will pursue those claims with great energy and vigor and determination. That is a separate matter and a different channel and an entirely different matter than the question of a trademark registration for a disputed trademark.
Right, but how is the ultimately we're talking about these claims. One is, and in all cases we're talking about confiscation of property, right? So, I mean, in those cases where we're talking about the confiscation of property, why is it different in this case with the confiscation of a trademark versus the others? Well,
one of the differences in this case, and there are several in terms of the type of matter to be decided, not by, again, not by the State Department. But one of the differences is that in this case, the property which was confiscated that this trademark is associated with was not held by a U.S. national at the time of confiscation. So it does not, under the law that we're operating under, it doesn't become a matter for us to be pursuing through the claims discussions. So that is one of the differences. And I just would encourage members of Congress to consider the broader game here, which is the pursuit of the claims of U.S. nationals worth billions of dollars against a government that will not necessarily go easily into recognizing these claims. So we are going to go after those with great energy, and we should.
I do, and my time is up, but I appreciate the suggestion and your urging that I consider those. I consider those very seriously. That's why I'm concerned about the possible precedential value, that the possible precedent that's being set in the way this claim was handled, or it almost with the appearance that this one will cast aside to perhaps give us some greater leverage as we discuss these others. That's my concern, but I yield back, Mr. Chairman.
Thank you, and I'll be brief because I know we have a second panel. One, isn't the $2 billion the original value? Isn't it $7 or $8 billion? Isn't there interest to be considered? You may not be claiming it, but the value of money over a lifetime plus.
I'm not certain of the facts of that.
Well, aren't the 6,000
we'll get back
claims?
to you on that.
The 6,000 claims were about $2 billion at the time that they were certified. So we're going to assume that there are a multiple of that at some point. But let me just, to be honest, call you out on something that I'm concerned the way you said it. You said the broader game. Now, this country welcomed tens of thousands of Cuban refugees to our shores. Those tens of thousands of Cuban refugees, including those who spent time in prisons and fled, those who died, some of them died on the boats and some made it here. Those Americans, you've said repeatedly, are not part of your calculation. Isn't that true? They're not, and please don't tell me about international law. I just want the straight answer. Those tens of thousands of Cubans who fled to our shores, who we granted asylum and citizenship from a totalitarian dictatorship that oppressed them, that had no rule of law, they are not part of the current negotiations that you are trying to work with the Cubans, and yet you use the word broader game. Isn't that the broader game? Isn't the broader game justice for the tens of thousands here and the hundreds of thousands still in Cuba, that they get their rights? Isn't that the broader game for America?
Well, Mr. Chairman, as I've stated previously, the Foreign Claims Settlement Commission has recognized the claims of people who were U.S. nationals at the time of confiscation, and we're pursuing those claims vigorously through the negotiations.
Well, isn't your responsibility, your position, Mr. Secretary, include taking steps to eliminate trafficking in stolen U.S. property?
Yes, sir.
So, U.S. property is sitting there, perhaps a home that a U.S. citizen in 1960, and certainly homes and businesses of U.S. citizens today. That's where rum is being produced. It's where Coca-Cola copy is being produced. It's where cigars are being produced. So anything that we allow to come, including Havana Club rum, very, very possibly is coming from assets seized illegally, held by Americans, and your responsibility is to see that it doesn't get trafficked, isn't it?
Our responsibility is to uphold and implement U.S. law on all these matters.
So, again, I'll go to the Commissioner, and please, this is within your jurisdiction, and I would ask that you use the level of career professionalism and not tell me that somebody I haven't yet brought before this committee is the person to ask. We talked earlier, and the round of questioning was rather interesting. The first question, there's abandonment, and then there's an inability to ship the goods. to, in fact, use your trademark, correct? Okay. The original trademark holder, who's one of the still applicants, that family, their assets were, and they're American citizens today, their assets were seized in Cuba. Their product, if their assets were lawfully returned to them, could be made in Cuba and shipped from Cuba, couldn't it? Well, I won't ask you to hypothecate that.
Can't.
Right, but the fact is, they have a factory, or had a factory, in Cuba. If they didn't have to flee as refugees recognized by us, for asylum recognized by us, after a totalitarian dictatorship jailed them unlawfully, oppressed them, if they hadn't fled here, they could still be there. If they could be there, then they could ship from Cuba. So when the question about Havana Club and origin, once Cuba returns to rule of law, once it returns to where the family can regain what was taken by it, in no different matter than the Nazis took things, this government nationalized. They took assets. They gave no compensation. So the fact is, Havana Club has a factory in Cuba, except it belongs to someone who's an American citizen. So is there within your recognition a circumstance in which, as long as a military junta holds on to the asset that makes the alcohol, that family is unable to secure the money for their trademark or to ship from their native country of Cuba because their factory is being held by a military dictatorship? Isn't that every bit as valid a reason for the family not to be able to ship product and thus reclaim their trademark? You know, the Cubans say we can't ship. Cuban government says we can't ship because we have an embargo. But this family can't ship because the Cuban government took their factory, their distillery, and still holds it today.
I believe I stated earlier that they could have preserved their registrations by claiming excusable non-use back in the 50s.
But you have the right to waive any limit to go back and find those circumstances. You mentioned you didn't have time limits. If the family came to you today and said, we want to reclaim it because we've been unable to ship from our country of Cuba, from our factory, because a dictatorship has taken it and seized it, you have the ability to grant that today. There's no time limit on that, is there?
I don't have the ability to do that today because there is a blocking registration.
Oh, that's right, because you were ordered by the State Department to grant a registration to the Cuban government that seized their asset.
I was
the same State Department that's not going to protect the rights of those refugees and asylees and their families, the tens of thousands of Cuban Americans who fled Cuba or were imprisoned and then got out of Cuba on a boat. They won't protect them, and you've granted a trademark to the Cuban government that did that, and that's going to block it today? Is that your testimony?
I was not ordered by the State Department to do anything.
Well, you were provided the legal information necessary to compel you to give it, because you said you had no choice once OFA delivered that.
The Department of Treasury, I believe,
Treasury.
is where the OFAC
Treasury.
is. Yes. So once the OFAC issued the
I apologize
specific-
for saying OFAC Treasury. Thank you.
once
The
OFAC
problem is we have state here telling us that this is the bigger game that we need to understand.
I understand that. I'm just a very small part of it, and I got a license from OFAC, and so then I followed the law.
Right. You had no choice but to provide a trademark to a dictatorship that seized their assets, and that now blocks the original owners who had it seized from them and whose children and grandchildren are fairly destitute today comparatively because, of course, they don't have the assets to make their distilled spirits.
Is there a question?
Well, yes would be fine.
I had no choice but to renew registration number 1031651.
Well, thank you. I think although the record is not complete, it is certainly complete as to what the broader game is by the State Department, and the fact that you had no choice but to grant an injustice by renewing to a dictatorship that seized somebody's assets, their trademark, which will now, I predict, be used in federal court for the presumption in favor of Cuba. And that is what you have done here today, or have done. You have changed the presumption in the court. I will tell you, your testimony, Mr. Tong, that you don't think it's going to change the presumption, I don't think you're right. I think it will change the presumption. It shouldn't. And certainly I hope Congress passes a resolution hoping that the courts will recognize that your actions should in no way change the presumption of who has the actual right and who has had the right to that trademark since the 1930s.
Mr. Chairman, the presumption has been in place since 1976, so we have maintained the status quo.
I hear you, but no one was shipping any product. Today, this product is being sold in at least 19 states. And notwithstanding the renewal, there's certainly 19 states worth of common law rights, rights that in the ordinary course would not be stopped. And I would presume that the Cuban government will seek to stop Bacardi in court. They will try to stop the sale of this even while they cannot sell the product. We'll see how it works out. The one thing I know is the lawyers will get rich, the administration will move on, and the thousands and thousands of Americans whose parents and grandparents fled Cuba will feel undercut if you're only looking at 6,000 people who may have lost a stock or a bond but were Americans sitting here. And I hope this administration will reconsider the broader game and understand that the broader game includes all Americans, not just those who were Americans in 1960. If you have any closing comments, I certainly want to hear them. And with that, this panel is dismissed, and we'll take a 5-minute recess while we set up the next panel.
Thank you.
I want to welcome all of you back, and I take pleasure in introducing our second distinguished panel of witnesses. Once again, the witnesses' written statements will be entered into the record in their entirety, and I would ask that you summarize your testimony in 5 minutes or less. To help us stay within the time, you see the lights, you know how the lights work, I will say no more. Before I introduce the witnesses, pursuant to the committee's rule, I would ask you all please rise to take the oath and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Please be seated. Let the record indicate that all witnesses answered in the affirmative. Our second panel of witnesses today includes Mr. Rick Wilson, Senior Vice President at Bacardi Martini Incorporated. Mr. William Reich, President of the National Foreign Trade Council. I apologize. I'm not going to drink that. Mr. Mauricio Tamargo, attorney at law of Tamargo LP and former chairman of the Foreign Claims Settlement Commission, which certainly was talked about by the previous panel. Let me do this again. And Ms. Escacena, a Cuban property claimant from Miami, Florida. And just for the record, are you one of the 6,000 that is in that stack that was referenced earlier? Okay, so you are a claimant but not certified. You lost property but are not recognized. I just want to make that for the record. And with that, I will go down the list, starting with Mr. Wilson. Okay, now we're going to play the mic game again. Yeah, that's great.
Thank you, Mr. Chairman. Committee members, good afternoon, or almost good evening, I guess. My name is Rick Wilson, and I'm Senior Vice President, External Affairs for Bacardi. I'm here today to testify about the recent decisions of OFAC and the PTO, which issued a license and a trademark registration for the illegally obtained and now expired Havana Club mark, 10 years after the statutory deadline. These decisions are unprecedented and shocking because they undo decades of U.S. law and policy by sanctioning Cuba's efforts to capitalize on and traffic in stolen assets. This dispute has a long history, and I will not go through all the facts, and I ask the committee to look at my written comments. I do have to say a few words, a little bit about history. You know, the Bacardi and the Arechabala families were both very similar companies. They originated in Cuba in the mid-1800s. We both created rums and operated in a similar fashion until 1960, when armed forces of the Cuban government, under the leadership of Fidel Castro, forcibly seized the company's assets in Cuba without compensation, throwing family members in jail or forcing them to flee the country. And I just have an example, and we have the original, by the way, in our office. This is actually the front page of the newspaper that talks about the confiscations. And on the last page, actually, is the list, which have been circled, of the Arechabala company and the Bacardi company, in case there's any doubts. Unlike the Arechabala family, the Bacardi had assets outside of Cuba and successfully stopped Cuba from selling rum under the Bacardi name around the world. We had to fight him in a number of places. Unfortunately, the Arechabalas did not have those assets outside of Cuba and were unable to continue their business. After losing the fight for the Bacardi brand, the Cuban government, they lied in wait. And in 1976, you heard earlier, after the family's U.S. trademark registration understandably lapsed, Cuba fraudulently registered the mark for itself. Years later, then it sought an OFAC license, by the way, to transfer that illegally obtained registration to that joint venture company you heard about earlier, half owned by Pernod Ricard, a French liquor company that today is the second largest spirit company in the world. OFAC back then properly denied that request. However, the Cuban government would be faced in 2006 with another need to renew its illegally obtained registration. But this time, a very important law had been passed by Congress called Section 211, which specifically requires confiscators and their successors to seek a specific license to obtain or renew a trademark registration for Cuban confiscated trademarks. Cuba applied for such special license, and OFAC refused to grant it back then, stating, and I quote, "We have received guidance from the State Department informing us that it would be inconsistent with U.S. policy to issue a specific license authorizing transactions related to the renewal of the Havana Club trademark." And indeed it was, and indeed it still should be. As a result of OFAC denying this license application, the PTO denied the trademark renewal, stating that the registration will be canceled, expired. Again, this, as was stated earlier, 2012, all the litigation regarding that ended. The Cuban government sued the U.S. government during this time frame, and OFAC specifically defended its decision to deny the license application all the way to the Supreme Court, which declined to hear the case. That should have been the end to the matter. However, in unprecedented fashion and for unknown reasons, the PTO refused to remove the canceled mark from its register for years. And recently, on January 11th, 2016, OFAC unbelievably reversed course and granted Cuba a license which purports to authorize payment of this long overdue filing fee from 2006. So within 24 hours of learning about this decision, a speed which is likely unmatched in the chronicles of administrative law, the PTO granted Cuba's 2006 petition to renew its trademark. Granting a specific license to renew Cuba's invalid registration allows the Cuban government to illegally maintain its claim of title to United States property, which is acquired through the forcible confiscation of the Derecho assets and forced exile of its founders. Indeed, intellectual property law is undermined, not strengthened, when states recognize rights in confiscated marks. Whether the Cuban embargo is strengthened or weakened, it will always be important to ensure that the United States does not become a party to Cuba's illegal confiscation of private property. Recognizing Cuba's ownership of the U.S. Havana Club registration, as OFAC and PTO have now done, will only serve to legitimize Cuba's thievery. What occurred was a forcible confiscation at gunpoint. For decades, the U.S. has prevented Cuba and its business partners from profiting off of the United States Havana Club registration. It should continue to do so. Well-settled U.S. law and policy, as reaffirmed by Section 211, ensures that the U.S. will always protect the creators of intellectual property like us and not reward those rogue states like Cuba, which use force of arms to steal such property and enrich itself at the expense of its citizens. The sudden and unexplained decision of OFAC and the PTO to permit Cuba's renewal of the Havana Club mark flies in the face of these legal and policy principles, and this action should be retroactively revoked. Thank you very much.
Thank you, Mr. Reich. Yes, sir.
Yes. Thank you very much, Mr. Chairman. My name is Bill Reinsch. I'm the president of the National Foreign Trade Council, which represents 200 American companies engaged in global commerce. The NFTC strongly supports the Obama administration's efforts to place relations between the United States and Cuba on a more normal footing. Resolving satisfactorily the legitimate claims of U.S. citizens who had their property in Cuba confiscated by the Castro government is essential to creating the conditions in which a normal relationship with Cuba can thrive and endure. Constructing new impediments and perpetuating those that already exist will only complicate this process and make it more difficult to secure the recompense that U.S. property holders have sought for decades. Tonight I want to focus my testimony on an important intellectual property issue that, if not resolved correctly, will adversely affect our country's standing in international organizations, our ability to lead the global effort to protect intellectual property rights, and our efforts to protect the property of U.S. citizens and companies doing business in Cuba in the years ahead, and that is Section 211. As the committee is aware from its hearing on this subject in March 2010, where I also had the honor of appearing, Section 211 was found in 2002 to be in violation of U.S. WTO obligations. Some 14 years later, the United States remains in noncompliance. Section 211 also has put the United States in violation of its obligations under the General Inter-American Convention for Trademarks and Commercial Protection. On behalf of the NFTC, I want to express our support for repeal of Section 211, which is contained in provision for which is contained in a number of different bills, which I enumerate in my statement. I also want to express my opposition, I'm sorry to say, Mr. Chairman, to your bill, H.R. 1627, which purports to address this problem in a different way, but in fact would only exacerbate it. Repeal of Section 211 would remedy the U.S. breach of its WTO obligations and the Inter-American Convention, and my written statement provides details about that. While it would also remove any pretext for the Cuban government to remove protection of trademarks currently registered in Cuba by U.S. companies. At present, there are more than 5,000 U.S. trademarks registered in Cuba by over 400 U.S. companies. Many of these companies look forward to the opportunity to sell their products in Cuba, and they will want to know with certainty that their trademarks will be protected by Cuba as they build their plans to develop that market. Repeal of Section 211 also would restore the traditional U.S. leadership role on intellectual property issues, which has been compromised by our failure to comply with the WTO ruling. This has provided over the past decade a convenient excuse for other WTO member countries, such as China and India, to ignore U.S. calls to improve their IP laws. Repeal of Section 211 would confirm the U.S. commitment to providing high standards of IP protection, including our commitment not to assign trademarks based on political criteria. It will also reaffirm that resolving trademark disputes are properly the responsibility of the Patent and Trademark Office and the courts based on the merits and not on political considerations. Section 211 has no benefits for the U.S. business community and is far more likely to cause significant damage. If it's maintained in law, it could provide, as I said, a pretext for Cuba to withdraw protection for U.S. trademarks currently registered in Cuba by American companies. It could also become one more roadblock to the efforts to the United States to reach agreement with the Cuban government on a satisfactory resolution of the outstanding claims that will be the topic of the next two witnesses. H.R. 1627 or other proposals short of full repeal, we believe will make things worse. For the benefit of a single company, the proponents of Section 211 and H.R. 1627, in effect, are asking the Congress, one, to make it more difficult for U.S. companies to enforce their trademarks and trade names in U.S. courts against claims of ownership, two, to keep U.S. countries exposed to the risk of retaliation abroad and the type of injury that they suffered in South Africa in a comparable situation, and three, to continue putting U.S. law at cross purposes with longstanding principles of U.S. trademark law and important IP and trade policy objectives of the U.S. business community and the U.S. government. And my written statement has further details on those points as well. H.R. 1627 would seek to apply Section 211 to both U.S. nationals and foreign trademark holders. However, such an amendment has significant drawbacks when compared with repeal, the main one being that it would not address any of the inconsistencies of 211 with the Inter-American Convention. In addition to the risk to U.S. companies abroad, such a partial approach would also lead to increased litigation and legal uncertainty at home. In sum, Section 211, even if amended by H.R. 1627, would continue to benefit only a single company and provide no benefits for U.S. business. Instead, it would make it more difficult for U.S. companies to enforce their trademarks and trade names in U.S. courts against counterfeiters and infringers, and keep U.S. companies exposed to the risk of legal uncertainty and retaliation abroad. For NFTC members, this is a bad bargain that harms both U.S. business and U.S. national interests. Instead, we urge Congress to repeal Section 211 in its entirety. Repeal is the only action that will provide full compliance with all current U.S. trade obligations and deny other governments any rationale for suspending their treaty obligations or retaliating against the trademark and trade name rights of U.S. businesses. This is all the more important as the United States moves to reestablish a normalized relationship with Cuba. Repeal of Section 211, we believe, is an essential element of establishing that relationship. Finally, Mr. Chairman, I want to reiterate what Secretary Tong and Ms. Dennison said, and that is to note that repeal would not take sides in the underlying dispute over the Havana Club trademark, and it would not settle that question. Rather, it would return that dispute to the Patent and Trademark Office and the courts, where we believe it belongs. Experience shows that the courts are more than capable of reaching a just and equitable resolution of that dispute based on the merits. Thank you for the opportunity.
Thank you. And just as we go on, you do also, one of the 200 companies you represent does, in fact, currently hold the trademark, correct?
I'm sorry?
The maker of Havana Club is one of the 200 members of your consortium.
If you're asking me if Pernod Ricard is one of our members, the answer is yes.
Okay, I just want to make sure that
yes.
It's not the 199 as much as it's the one.
Well, no, our members are the U.S. subs, and in some cases, I would argue that there's 200 American companies, but there's other companies as well.
Mr. Tamago.
Thank you, Mr. Chairman. And members of the subcommittee. It is an honor to appear before you today. I commend this subcommittee for convening this hearing and for including certified claims against Cuba. I hope the subcommittee continues to play an active role in the long overdue settlement of these American claims. Over 55 years ago, the communist government of Cuba confiscated real and personal property of thousands of Americans and others living and doing business in Cuba. To this day, that chapter represents the largest confiscation of American property in history, and there has been no progress in settling the claims or addressing other potential Cuban debts as called for under U.S. law. Caveat emptor, or buyer beware, is generally the rule in international commerce, but not when a foreign government injures an American or confiscates his or her property. In those cases, it is the responsibility and the expectation that the U.S. government will do all it can to achieve justice for its own nationals. Under international law, all countries are expected to do the same for their own nationals. The confiscation of American property by Cuba was so significant that the U.S. government enacted certain trading restrictions regarding Cuba, which have become known as the Cuban embargo. The U.S. Congress has repeatedly declared that this embargo will not be lifted until the American certified claims are paid and settled by Cuba. That was the promise made to by the U.S. government to the claimants. Unfortunately, both Democratic and Republican administrations have weakened the sanctions on Cuba without securing concessions or commitments from Cuba regarding the claims. I'm encouraged but guarded by the ongoing negotiations between the United States and Cuba regarding the possible settlement of American claims and related issues. There are 5,913 certified claims against the government of Cuba, the last two of which the Commission certified under my chairmanship. When all claims are certified, they are valued at $1.8 billion. Today, they are valued at $7 to $8 billion, and I thank the Chairman for that clarification question to the Secretary, because with interest, they are valued closer to $8 billion. No American claims program has been left pending and unsettled for this long. Under international law, the Cuban government can confiscate property, but the U.S. has a right to fair compensation for its citizens. I believe the U.S. should agree to nothing less than full amount of value for their claims plus 100% of the interest. Cuba can and should pay this price. Cuba should not get a free ride for stealing American property, sometimes by force and without compensation. A few recommendations to the Congress. First and foremost, these certified claims were the reason the embargo was created in the first place, and Congress must not pass any legislation which further eases the embargo unless these claims are settled. The U.S. gets only one shot at this. We have only two things Cuba wants: access to credit and access to the U.S. marketplace. If the Congress gives those away or allows them to be given away without getting these claims paid, then the Congress will have failed to stand up for these American families and companies. It is also inviting other countries to take more American property. Second, I urge the Congress to enact legislation granting limited authority to the Foreign Claims Settlement Commission to update the certified claims with a current claim holder of interest for each claim. As I explained, claims programs are not designed to go unpaid for 55 years. Multiple generations of claim holders have come and gone, and it will possibly take years to ascertain the identity of the current claimants. Not only is it good governmental housekeeping with no additional cost to the taxpayer, but it also sends a strong message to Cuba. Thirdly, although I am optimistic that the certified claims will get paid, you never know. We've been waiting for 55 years, and we may get more of the same status quo. Therefore, I propose the following. We know the current government, the current American trade and travel business with Cuba is trespassing on American property. We know this because a runway expansion at Jose Marti Airport was built on land subject to a certified claim. And the same is also true of most other Cuban air and seaports, including the Port of Mariel and much of its infrastructure. They all are on land which is the subject of an American claim, and there may be other debts by other Americans and foreign nationals. If these talks fizzle out, or Congress should consider enacting a trespass penalty of 10% on all transactions with Cuba. That would be on all trade, travel, commerce, remittances, toll calls, gifts, flyover fees, port duty, everything. The proceeds collected by this trespass penalty would go into a fund which would pay all certified claimants their full amount until, including interest. This trespass penalty would not release Cuba of its debt, but now the debt would be owed to the U.S. government instead of the individual claimants. Those doing travel and trade with Cuba should consider this trespass penalty as the cost of trafficking in stolen property. The current and seemingly never-ending waiting by the claimants is unacceptable and intolerable. It is the responsibility of the Congress to end this embarrassing 55-year wait by our fellow Americans. Fourth, I recommend that and urge all American families and companies that are holding certified claims to become engaged in this discussion. Write your congressman, your senator, the president, the State Department, and continue writing and calling until these claims are settled. American taxpayers are owed compensation by Cuba. They need to demand that their claims be settled, and if they're not going to be settled, they should be paid by the trespass penalty. It is wrong to continue to hold claimants hostage to this seemingly never-ending battle over Cuba policy. It is unfair to many American families who did nothing but courageously go to Cuba to build a business or try to start a new life. Thank you, Mr. Chairman and members of the subcommittee.
Thank you. Ms. Escacena.
Thank you, Mr. Chairman, and thank you to the members of the committee.
I think maybe pull your mic a little closer.
A little bit closer?
Yeah, please. Thank you.
Thank you for giving me this wonderful opportunity to tell my story. I am a Cuban-born and American citizen. My family left Cuba in 1960. They silently planned their exodus for fear of persecution. They also had to plan financially how they would survive this exile. No matter how terrified they were of their immediate future, their mentality was that this would not be permanent and that they would return to their beautiful island once again. My grandfather, Federico, on my mother's side, came from a humble beginning. He was born in Caivaria in Las Villas, lost his dad at the age of 9, and in order to help his mother provide for him and his 4 siblings, he worked on the docks after school every day. He would finish high school before he began working full-time. While his future looked promising, the financial crisis in 1929 left him jobless. He took all the savings he had, his experience and contacts, and became a steamship agent, opening his own office as a custom house broker in Caivarien, and some years later in Havana. He would then open sub-agencies in every key port in Cuba and an office on Wall Street. In 1938, his success in Cuba would get him recognized by the U.S. and make him a consular agent. My grandfather had finally built a name for his family and their future generations. My father, Manolín, started at the age of 10 working alongside his dad to help create and build the family business. My grandfather, Manolo, started a company of explosives that would later be contracted for mining and the creation of roads throughout the entire island. Their growth and success would soon move their main factory and operations to Havana. The business continued to flourish, and my father continued making large investments, aiding the growth and expansion. Castro's regime of terror started by confiscating properties from big landowners, arresting and accusing innocent individuals of being against the government, sending these individuals to the firing squad without a trial. Castro will stop at no cost. The Cuban reality came knocking at my parents' front door, literally, when Castro's men came searching for my father at gunpoint. Their demands were simple. They would take my father's business, his factory, equipment, and offices, and all of the land. My grandfather, Federico, was stripped of his 4 homes in Miramar, his business, commercial property, and all other equipment from which he ran his operations. Currently, my house, where I was born, is an embassy, for the record. Not only did Castro steal physical property that belonged to my family, but also destroyed the legacy that they worked their whole lives to build and someday pass on to the children and grandchildren. And even though the Castro brothers, and others said they would pay the family for this, They never did. My family was not the only one to suffer this fate. Hundreds of thousands of Cuban families and Americans were forced to leave their homelands and everything they built. After over 55 years of the same communist dictator continues to destroy the beautiful island that more than 1 million of Cuban Americans used to call home. The time is long overdue for the U.S. government to acknowledge and demand restitution for all the Cuban Americans and so many other victims of Cuban communism. We have pledged our allegiance to this beautiful country and ask that our country help us secure justice. While the properties that were stripped from us may hold a monetary value, the pain and suffering of my parents and my entire generation is far greater than any dollar amount. My parents longed to return to Cuba, the country that they adored, to smell the ocean in Varadero, to walk El Malecón, to feel free once again in their ancestral homeland. They passed, never being able to fulfill these dreams. Although my parents couldn't fulfill these dreams, I am here to see their dreams out for them and for every Cuban American family. These dreams are not driven by money. They are driven by the need for justice, the same kind of justice the U.S. advocates to the people of this country. Today, I feel you have offered our family and others like it an opportunity to help start to right these wrongs and begin to heal very old wounds. You honor the memory and sacrifice of our families, and for that, we thank you. Please, help all victims of Cuban communism seek justice. Thank you.
Thank you. That's a very compelling story. We now go to the gentleman from Florida, Mr. DeSantis.
Thank you, Mr. Chairman. Thank you for the testimony to the witnesses. You know, this policy is frustrating because you have a country and a regime that has been hostile to us since its inception at the revolution. They confiscated all this property. No one's ever been given recompense for that. They've tortured people. They've imprisoned people for political purposes. During the Cold War, they would export guerrilla fighters to do our enemy's bidding. And so now we are with this regime. They're harboring one of the FBI's most wanted terrorists, Joanne Chesimard. And so we do this change in policy, and what are we getting? And I think Mr. Tamargo said we should not give them a free ride. Unfortunately, I think the administration is doing exactly that. All this property should have been paid as the price of negotiation. And yet we're showing basically, we're providing the Castro brothers a road where they can get away with this because they're getting some of the cash and credit they need. They're getting the lifeline that they need. But you still have Joanne Chesimard there. You still have all these claimants who had their property seized. And so I think it's very, very frustrating. And you even have outlets like the Washington Post editorializing, hey, this is not working. The Castro brothers are not changing. Let me ask you, Ms. Escancina, has the administration listened to your concerns?
Not to my knowledge.
So do you feel a sense of betrayal that they're not listening to you or doing anything for you?
I feel that he has not reached out to any of us, any of the Cuban Americans, and had not heard our stories.
Now, Mr. Wilson, the State Department testified, you were here for that, and they basically said, look, we want this, the courts are going to resolve this issue in terms of the Havana Club run, but hasn't this issue already been resolved?
Yeah, yes, Mr. Congressman DeSantos, there's been tons of litigation already, and actually unfair litigation that we and the Rechabalas have had to endure for years. And yes, with this action, we're going to end up having to do more litigation and attempt to make sure that the wrong is righted. But the problem is, and I think it was stated earlier in the first panel, why should families like the Rechabalas have to resort to litigation? Why? That's why Section 211 was passed, because there's a bright line rule there, not to recognize those confiscatory measures. Look at the Rechabalas. They were put out of business. Their family lawyer was put in jail for 18 years. They didn't have advice. They didn't know how to do things in America. And now they're going to be resorted to have to go through expensive litigation. That's not fair. And I'm concerned that our government starts their path down to resolve these confiscations, and the first one they start with is to recognize the rights to the confiscator who took the rights from that family.
Not providing great incentives for future behavior. I mean, that's for sure. Mr. Tamargo, you mentioned, and I think this is a good point, you know, you're talking about expanding commerce with the Castro regime. You know, so someone pulls into a port, that port very well may likely have been seized by a private property owner. Someone staying in a hotel, that may very well have been seized property. So some people have this argument that, oh, you opening it up, you can create, you know, more markets, and this is how, you know, economies change and societies change. But, you know, free enterprise depends on the rule of law. And this is basically in conducting commerce on the backs of confiscated property. So it's really undercutting the rule of law because the regime's going to now profit even more based on the actions they took. So do you agree with that?
I certainly do, Congressman. It's worth pointing out that the licensing that Treasury is issuing for a lot of this commerce and travel and trade and shipping is using confiscated property that has not been compensated, and that's contrary to U.S. law. And they simply issue the license, but they don't inquire or drill down in the application enough to bring that to light, and that's how they're able to issue this license without having to admit that they're in violation of the law.
Well, I appreciate the testimony. I mean, the bottom line is this is a major change in policy. We've seen the Cuban regime benefit. And here's the thing. They've been trading with all these other countries for this whole time. Has that benefited the people of Cuba? No, it doesn't, because the money goes to the military, the intelligence services, and the regime. It doesn't go to the Cuban people. And so this is a benefit to the Castro brothers. And for us not to get even one claim paid before we've gone down this road, you know, I obviously think it's bad policy. But I really appreciate the chairman calling the hearing. And Congress needs to stay engaged in this issue. I yield back.
Thank you, and thank you for your insightful questions. I'll now recognize myself for a few questions. Mr. Tamargo, you're an expert in the area of these claims, and you worked on it, and I thank you for your efforts with the Commission for a very long time. You proposed essentially Congress acting to reopen. Could you elaborate a little bit more on that? I want to make sure I understand it, because it does seem like the only way to get justice, and I'm going to take Mr. Reich a little bit to task here. If I understood him correctly, he sort of called our treatment of South Africa when it was an apartheid as a failed policy that didn't work. And I'm old enough.
That was not what I said, but we can discuss it later.
When you referenced it as not going down the road of South Africa, I must tell you, I'm very proud that America and the world went down a road with South Africa and forced a change. So as we look at forcing a change, if this administration won't do it, or at least accounting for that change, would you go through the benefits of reopening and of properly assessing the claims?
Yes, thank you, Mr. Chairman. This is a proposal that we've been advocating for a while now. It is the Commission, when it adjudicated these claims, it completed its work in 1972, and by statute, its authority ended over the claims. And the claimant is the one responsible for keeping his own records current, but that was 40 years ago. And,
so
and
what you're saying is people die, there's probate. The only way to really know that $7 or $8 billion who's entitled to it would be to essentially allow the Commission to reopen and evaluate who they are.
While I was there as chairman, we did try to unofficially update the records as best we could. We did research, we contacted claimants, we reached out with outreach efforts, and we did a fraction of updating. But even that is unofficial, and we don't have the authority to require documentation that would prove their actual ownership. And I suspect that many of the claimants of record have conflicting interest in the same claim because nobody knows for sure. There is no authority to determine who is the actual claimant. That normally gets sorted out by the Treasury Department when it's distribution time by when the offending country pays the settlement amount, then its distribution happens at Treasury. But the claims programs don't go 55 years unpaid, so we're in a new situation here, and when and if there is a settlement with the government of Cuba, it'll take quite a bit of effort for Treasury to find out who are the appropriate recipients of these certified claim amounts, and it'll just take too long. I mean, I believe this is time being wasted. The Commission has the expertise to do this updating of the records. It's already budget. They have a staff. They could be doing this under their own authority, and they could be with limited reopening of the program, not to revisit the amounts or anything, but simply the identity of who the certified claimant is supposed to be. And that would be what I would propose.
So unless we want to go to Ancestry.com to find out all of this, we must find a way to make sure that the records stay current so that if there's a disagreement, it can be adjudicated by a family. Because, I mean, we all understand that Mom left everything to you but didn't name that asset. When you die, who's to say that your siblings' children aren't going to make the claim since it wasn't named in the will, just as an example?
It's a very good example. It's gonna, these family probate matters get very complicated, and Treasury normally would sort through that, but they only do like, they don't have this many of them to do. I suspect there's going to be 5,000 of them or maybe 5,500 of them to do, and it'll just be quite an undertaking. The probate cases would have to be probably opened in many cases to begin a probate process that never was done because there was no assets at the time.
And Ms. Escanana, as I apologize. This is one of my worst things is pronunciation of names. And with a name like Isa, go figure. You mentioned, though, that your family home was large enough that today it's an embassy. It's an embassy of whom?
It's the Embassy of Belize.
Okay, now, an embassy is sovereign land of the country that occupies it. So if I'm to understand, the Cuban government at gunpoint took your family home and has sold it and made it a sovereign asset of another country. So Belize took you as an American. They took your land and they sold it to another country that now occupies it and considers it their embassy, their sovereign land. That's your testimony.
Yes, that's what it appears, and we found out actually last year that it was an embassy.
And it's a small amount of the assets that were taken, but meaningful.
Correct.
Mr. Wilson, I'm going to ask you a little tougher question. The Bacardi family at the time of the revolution were Cubans, is that correct?
Yes, sir.
They were Cuban citizens.
Yes.
They had assets outside of Cuba, but they resided disproportionately in Cuba, correct?
Yes, most. I'm sure most. I don't, you know, it's a large family. It's much larger now, but most for sure.
Okay, so the corporation was based in Cuba, correct?
Correct.
So I just want to make sure I understand. I'm holding up Havana Club, but I could be holding up a bottle of Bacardi. I want to make sure I understand this as best you can legally. If it was legal to take this from one family, then whatever the legality of their already selling everywhere in the world, 80% of the world's economy is not the United States. They're already selling this in 80%. Is there any legal difference in your mind between what they did to one family and what they would have, could have, and if we're to believe the State Department, essentially should have done to the Bacardi family, which is they should have your company's name and be selling it and reclaim it, at least in America, based on the fact that they took it, therefore they should have it. Am I missing something in the understanding of property rights?
No, Mr. Chairman, you're not. And they attempted very much to do that same thing to Bacardi. They very much did. They tried to. They produced a product and called it Bacardi and tried to sell it around the world. Fortunately, Bacardi had assets outside of Cuba, and so it could produce its Bacardi rum product and go to those same countries and fight in litigation and within the governments. And we won. Yes, we did. We were fortunate enough to be in that position. But many other Cuban families, like the Rechabala, were not in that position and are still not in that position.
Well, and the Rechabala family, I want to understand this because I think it's important to make the record complete. You did not wholly acquire the rights to Havana Club. You have a license agreement, effectively, don't you? They receive a benefit from every bottle sold.
We do have a commission agreement with them. Prefer not to go into the details.
No, and we don't need to know the details. The point is, was it Picard family company of France? They offered to buy it. They knew that there was a right, and they offered to buy it from the Rechabala family. But apparently, they were only willing to pay a de minimis amount and said, you know, we already have the rest of the world, but we'll give you a little something for the U.S., is my understanding. And
yes,
the late
there's
owner,
something similar to that. Yes,
right? The late owner came to your company's principals and negotiated a deal that he felt for his family was fair. Is that correct?
That is correct, sir.
And that arrangement continues today as the Picardi family expands the sales that you began in 1994. How many states are you currently selling in?
It goes up and down, but we've been, over the last 10, 12 years, we've sold in roughly 18 different states, but it goes up and down.
Okay. And you're unable to sell in the rest of the world because Cuba, what they stole, they got to keep by an agreement with a French company to distribute it, right?
Yes, the Cuban joint venture is selling that product throughout the rest of the world, really off of the unfair, illegal confiscations in Cuba, because that's obviously where it started, as I mentioned earlier.
Right. They obviously get all the assets. I did a little looking before this hearing, and Cuba exports about $5 billion of goods, some sugar, obviously Cuban cigars, and rum.
Mm-hmm.
They import about $15 billion. Now, the arithmetic of that befuddled me a little, so I did a little checking, and apparently what they import is the value, but they actually don't pay for it. A great deal of it comes from countries such as Venezuela that essentially it's a subsidy.
Mm-hmm.
So with 80% of the world's market available to this totalitarian dictatorship, this last remaining bastion of Stalinism other than North Korea, they basically have $5 billion of economy selling the whole rest of the world. So when Mr. Reich, on behalf of 200-plus companies he represents, talks about 4,000 trademarks that might be in peril, those trademarks, U.S. company trademarks, how many dollars of sales are there in Cuba by U.S. companies today, to your knowledge?
I don't have that number, but my
would
belief
zero be a
pretty
pretty
small.
round number, since there's an outright embargo and we're not selling?
I don't know specifically, Mr. Chairman, but there's some very small ag or medical
Right, I know
sales.
there's a small amount of exemptions, which brings up the point of if you applied for a license, since you have worldwide rights for Bacardi, would they recognize your trademark application in Cuba?
We do not own the Bacardi trademark there. Cuba Ron Corporation owns our trademark in Cuba.
Oh,
based
okay.
on
So
its confiscation.
they only recognize American marks unless, of course, they've already confiscated it. To your knowledge, has Coca-Cola been able to sell there? Didn't they seize all the Coca-Cola assets? Isn't that part of the six? Mr. Tamago, isn't Coca-Cola a major claimant in those 6,000?
Yes, both. Yes, they are. That's one of the top 10 or 15 claims.
And it was the operation there was owned by the Coca-Cola company, right?
Yes, yes, it is.
So it was a U.S. company. Had it been a franchise or some other agreement, they wouldn't get a penny, right? They wouldn't be on your list of 6,000.
Well, they wouldn't have been certified as an American claim. It would have been not an American claim. But it was an American company, so yeah, they were certified for, I think, $26 million.
Okay. Now, I'm just going to close with a question, and this is not intended to conflate the two, to say that these things are equal, but when you were dealing with these injustices, your commission, didn't it come out of basically the war crimes of World War II?
Yes, the commission is over 50 years old. Before those years, it was comprised of two commissions, the War Claims Commission and the International Settlement Commission, and they were merged together to create the Foreign Claims Settlement Commission.
Okay, so I want to go through the commission because we are going to look at legislation that falls under this committee related to that. Essentially, your legacy is that your commission is in fact the commission that looked at the confiscation by the Nazis, the Japanese too, but by the Nazis, the Italians, et cetera, in World War II. Now, you weren't empowered to take care of victims of the Holocaust unless it was an American family. How did that work?
Well, the commission did conduct a small Holocaust program, but it was back in the 90s. It was comprised of mostly American POWs when captured by the Germans who were put in Holocaust camps.
The work camps and so on.
Correct.
Okay, so
no, but otherwise the Holocaust
was separate.
Were separate.
But you did work with essentially assets that were stolen from Americans in that period of time in Italy, in France, in Germany, in Japan.
Yes, sir.
Okay, so your recognition is that these countries committed crimes, took money, took assets without any payment, and ultimately we made whole, as you said earlier, in some cases by an appropriation from Congress, but we made whole the victims, or we didn't quit with those countries. In other words, we didn't let Germany off the hook or Japan off the hook unless there was a resolution agreed and an agreement of who paid what, correct?
That's absolutely correct, Mr. Chairman. All claims programs were settled, the American claimants were compensated, and it was a condition of the offending country having normalized trade relations with us.
So this administration is ignoring the history of your commission, the history of it, by normalizing relations with absolutely no agreement other than we've agreed that we're going to begin talking. They have no agreement whatsoever to take care of those 6,000 people that you represent in some ways here today, and the perhaps tens of thousands of Cuban Americans who were not Americans in 1960.
It is possible that they are working towards that negotiated settlement which would result in the compensation of the claimants. That is my hope, and but what really I suspect holds them to that effort is the Congress needs to, the embargo for the most part cannot be lifted. The remaining parts of the embargo won't be lifted without congressional action, and the Congress won't accept, I would hope, a bad deal that does not give justice to the certified claimants.
So presuming the President, with the stroke of a pen and a phone call, doesn't somehow do it, there is one and only one tool left to force the Castros to properly compensate for what they did, at least as to American persons, 55 years ago, and that's the embargo.
Yes, sir. That is what I believe is the only thing that would bring them, that has actually brought them to the table right now, because their subsidized trading partner of Venezuela is faltering, as is their other trading commerce is faltering, and they would need this embargo to be lifted.
Well, I'm not a businessman the way I once was, but when I was a full-time businessman, and I looked at, if I looked at $5 billion out and $15 billion in, I would, as you say, be looking to change an arrangement. The one amazing thing I think that we all recognize is unless Cuba changes and allows their people to be empowered, even with access to an additional 20% of the world's market, I don't believe they can ever compete globally or even feed their people properly. Well, I want to thank all of you for your testimony. As in the last panel, we will leave the record open for 5 days. There may be additional questions from members who could not make it here this evening. This was a reschedule, and I appreciate all of you being able to meet the reschedule, but it wasn't at an ideal time for a hearing. Additionally, I would welcome any supplemental remarks you may have or information you want to put in, including matters for the record. And with that, you have my thanks, and we are adjourned.
Thank you.